So why can't ethics alone protect people? That is a necessary question which we must ask. Why can't ethics alone protect people? We already know that humans must be guided by rules and by laws. Why? Ethics actually has to do with our individual moral judgments. And our moral judgments cannot be enforced on anybody because the way I see the law today and what I see as good may be seen as seemingly good or almost good or as bad to some other person. So ethics on its own can't enforce and protect the people. Let's take, for instance, we looked at the concept of the WhatsApp last week. And when we saw WhatsApp platform, they simply brought out a rule asking us, do you accept to install our application or not? There's a disclaimer. Saying yes means that your information is shared with other third-party applications in the Meta ecosystem. But if we decide to reject to use the WhatsApp platform, it will mean that we are cut off communication from others. To WhatsApp, it is right to create those rules. But to we, it is wrong because the rules and their ethics is actually acting against our personal interests. But we can't do anything about it. We also saw the case of the week 2, the phase, that's the week 1, the Cambridge Analytica's case, where a game came up. And in trying to partake in the game, we were told to impute our personal information, including our house address, street address, and all of that. What now happened? Cambridge Analytica used it for political reasons during the election period. Now, to them, they were right. To us, they are wrong. How can we hold them accountable? It is only when there are laws and regulations that are binding, rules that we can always apply when we have a case, because ethics alone can't safeguard our people. Ethics actually creates no penalties for violation. If we rely on ethics and our thoughts, what we assume should be, there's nothing like an enforcement mechanism when a data law is faulted. Ethics also vary from culture to culture and from organization to organization. What my organization may see as private, your own organization may see it as public. For instance, in my organization, we take creating of forms very, very critical and necessary. But in some health organizations, they would always tell you, if we don't take such and such information during a survey, how can we produce drugs that will solve a particular crime? In health organizations, in drug manufacturing firms, they would always tell you that we must be able to carry out our tests, not just on animals, but we must do clinical trials on humans. Yes, we would seek their consent, but we won't tell them the overall effect it would have on them. Because if we tell them that we are testing a new variant of the Panadol medication, and while testing it, there are such and such side effects, we may not be able to come up with improvements to that. We see it as wrong, they see it as right. How else can we penalize and how else can we claim damages? It is only when the laws and regulations come into being and into practice. Because the laws actually create enforceable obligations by which all organizations must comply to. It is when we create laws regarding data and data use, most especially in this AI age, that we can have civil and criminal penalties apply once there's a breach of access. So laws is actually what establish minimum standards for penalties. Laws enable us to be accountable to our actions, and it helps us and protects us with legal rights. I've been talking about ISO certifications. Laws and regulations come in form of certifications, let's say ISO. For your organization to do business in the international community, you may be asked for ISO certification. Now we are talking about ISO 9001. What do ISO 9001 stands for? It's a certification that you must comply when you are in manufacturing, when you are in producing, but without doing that, your products cannot be used outside. It is laws that create that. Regulation actually sets the minimum standard, while ethics demand that we aim higher. Let's look at the US regulatory landscape. The United States on its own, they have no single federal privacy laws, no, because we have several sectors, and several sectors need their own rules and their laws regarding data usage. In the European Union, they have the GDPR that covers all sector, all data types, and all organizations. But US actually created patchwork for several specific laws. They have the one for health, they have for education, they have for California consumers. For instance, in my country, Nigeria now, we are now trying to create, we are in our country, we are not previously data mature. But right now, we are trying to create data laws regarding every sector. Now, most recently, we had the law regarding the use of social media. We also have the law regarding photography. And there's a law that recently came up that if you must take pictures in public relating to marketing, you must seek the consent of individuals appearing in the background. Individuals appearing in the background of your video or your picture coverage. If not, by the law that have been created, you can be sued. I can sue you if I see any marketing or promotional material on Facebook or any other social media and I am at the background. I can sue you because you didn't obtain my consent before taking that picture. So various countries now, they are beginning to be data mature and they are now taking privacy as very, very important. In the United States, why do they do patchwork? Because in the United States, unlike several other countries, various states have their own regulatory authority. That is why we are actually using United States as a case study. Some other countries may have some. So some other countries, they may just have a single rule overseeing the entire country. But in the United States, several states have regulatory bodies. Every state has a state police. Every state has how it adjusts data. Take for instance, when Donald Trump came in, President Donald Trump, when he came into power, he tried to enforce some rules. Various state governors came and said, this cannot apply in the state of California. This cannot apply in Texas. We must vote in our legislature if we want to adopt what the federal have decided or not. In the United States, like I said, they have the issue of the constitutional structure. There is actually no explicit right to privacy. Some states have what is called use of gun regulation. Guns are banned in some states it is not banned. Some states have the same sex. Some states say no. And we have the LGBT rules that applies to our own states. Laws are reactive and laws are not proactive. Now let's look at the health and the education law according to the United States. So for the HIPAA, 1996, when it was last updated, we have the Health Insurance Portability and Accountability Act. What does this cover? What sort of data does this cover? It covers healthcare providers. It covers health plans. And this is the actual clearinghouse for anything healthcare related in the United States. It protects patients' health information. It protects data linked to an individual. If you go online, you could be able to read exactly what it covers. That is why in the United States, a hospital can be sued. A doctor could be sued. They are performing a procedure and the patient needs blood transfusion. The patient's consent must be sought. Yes, I'm trying to save life, but you must do it with my consent because I could wake up from the hospital bed, even if I am cured, I could come back to sue the hospital. That is why most hospitals now they create various type of forms patients must sign. Sometimes you go through those forms, those documents, and you wonder why is this necessary? It is necessary because there have actually been an encounter, there have actually been a case. And the health law in the United States actually gives access, patient access to records. It accounts for disclosures. Everything you are doing must be disclosed. Majorly healthcare providers. If you run an HMO system, if you run an elderly people's home, you must have full disclosure. You must know exactly your rules, your terms, and your condition. You must know if you are out to outsmart the citizens or if you are out to protect them. And how is it enforced? It's enforced by the HS Office for Civil Rights, and fines could be up to 1 million USD per violation category. It was updated in 2024, and what was updated there, the rules that was updated was to strengthen reproductive health data. You could read it up and post in your reflective and your discussional forum. Now, we have the FEPA law that has to do with education. What does it cover? It covers all schools. It covers all schools receiving federal funding. It covers kindergartens, it covers colleges, and it covers universities. This has to do with educational records, grades, transcripts, disciplinary files, financial aid. Just today, I was called by an organization. I currently manage the ICT database for several international and local institutions. A call suddenly came in. I am Dr. Mrs. This calling from the military. We had a candidate that came for employment in our firm, and the candidate claimed that he or she schooled in your institution, and we need to verify if this is true or not. I was then reminded that this call is coming from the military directly, and I was sent an evidence of the admission letter provided by the candidates. I was given directive. Provide us proof of all his educational records. Provide us proof of his personal data. Now I have been teaching data and data privacy. I already knew that when the students came in, we signed a non-disclosure form that such and such information could only be divulged if there is an official memo, an official letter, which has been endorsed by the students. But in the case of transcript could be requested directly from an institution which you are applying for and we provide it. If you are to provide your personal information, you must give us approval to do that. By that rule and by that educational laws which we signed, it means that I have no rights, even if the military demands with force that I should share this personal information. I can't do that because I can be sued by the students. That is what we are talking about. Knowing the laws, having the laws, creating the laws, and following the laws. Some of us, after this training, you may come up to positions of creating these laws. Students 18 plus actually control their own records. Parents control minor records. Let's see the case of California. In 2018, California was the first to create a US consumer privacy law. US consumer privacy law. What are the key rights under that law? As a consumer, you have the right to know what data is collected about you and why is that data collected. As a consumer, you have the right to request deletion of personal data. Remember, we last week we talked a lot about that, about the different pillars of data privacy and the different pillars of data ethics. And we talked about the right to delete, right to know, and right to correct. Now we're talking about the laws and the acts that actually enforce that right. So as a consumer, under the California Consumer Privacy Act and Privacy Rights Act, you have the right to request deletion of personal data from any organization that actually have your data. If I opt out of a bank today, I have the right to tell the bank, I need evidence that my data has been completely destroyed from your database. I have the right to stop the sale of my personal data. I am with a mobile telecoms provider. And by the Telecoms Act, probably they have the right to share my personal information with other telecom providers. I have the right to tell my telecom provider in my country, I am no longer using the line. I have written a letter. Please delete every information regarding me from your database. Under the same act, you have the right to correct and fix inaccurate personal data. Probably you have gotten married, you have a wrong date of birth, wrong address. You have the right to request for your address to be updated. Still under this act, there's a right to limit usage of personal data. No company have the right to automatically enroll you to any voluntary participation program to share your data. And also under that act, there is no penalty for exercising your rights. You should be able to demand your rights without thinking that demanding of your rights will lead to any penalty. Now let's see some sector specific protection. We have the Federal Enforcement Act, Section 5. What does that mean? It prohibits unfair or deceptive acts or practices in commerce. Remember what we saw the other day? FTC fined Facebook $5 billion for violating this particular act in the case of marketing. They use user data for marketing. We also have the COPPA of 1998. What does it mean? It applies to Children's Online Privacy Protection Acts. It means that website and online services, you shouldn't collect data from children under the age of 13. That is why even Gmail, Google, Facebook, social media sites now, when creating an account, you would be asked what is your age. Once you impute that you are below a particular age, you can't proceed, or your parents will be you'll be asked for parental consent to operate a particular account. That was enforced because of this act that came into being. TikTok was fined 5.7 million USD for illegally collecting data from children without parental consent. How did we know they collected it? When they were asked to present their database, we saw that people's ages creating TikTok accounts fell below 18 years, fell below 13 years, meaning that there was no enforcement. Meaning that whatever the child is doing on TikTok, whatever pictures and videos are being shared, it is regarded that they are minors. And you should have known to block access for minors from creating an account on a social media site which can be hacked and which details and data on that site could be shared publicly. We also have the Financial Institutions Act, which is called the Gamma-Leach-Billy Act of 1999, which applies to financial institutions, bank, insurance, and investment firms. This is very, very interesting to me. I was teaching a course, 300 level students of cybersecurity, and we were talking about cyber crimes relating to data. A bank, an institution can commit a cyber crime If you have decommissioned a particular computer system or hard disk from your network, and the customer's data on that hard disk have not been disposed of properly, you are no longer using a system. Probably you are upgrading the bank's network. And when doing an upgrade, you are switching from HDD hard disk drive to SSD solid state drive. And when doing that switch, you simply did a switch. Where is the previous hardware? You have recycled it. You have thrown it in the trash. Anybody that have access to that flash disk and that hardware with good forensics knowledge can extract users' data. In cybersecurity, we call it dumpster diving. Dumpster diving means that you are done with a particular hardware, a particular system, and you put it in the dustbin. Someone simply comes to the dustbin, excavates all what you call trash, and extracts vital clients' customers' data from there. You could be fined for doing that. Any decommissioned hardware must be disposed of properly using the set aside principles for decommissioning hardware. It is as serious as that. Data crimes, data rules, data acts are now taking very, very important. What is actually changing in the US data law? Our advice was after this class, you pick up and check your various countries' websites. In Nigeria, we have what is called the NITDA, we have the NCC. You check their websites for applicable laws and acts and regulations regarding data and data privacy. And please, when you check it, study it carefully. Study it so that you know exactly the laws, the rules, and the acts that have been enacted regarding data in your country. And when you do that, please come to the discussional forum or the reflective journal and post your findings. I would very much love to read what each and every one of us find out from your various countries regarding the laws and the regulations regarding data privacy. What's changing in US data law? The American Data Privacy Protection Act has been proposed, though not yet passed. This would create the first comprehensive federal privacy law because it now establishes data minimization, consent requirements, individual rights, which is similar to GDPR, that is the General Data Protection Rule, and it has bipartisan support, but it also faces state debates. Also, the FTC is proposing commercial surveillance rules. Commercial surveillance rules. In Nigeria, we have some areas set aside by the military as out of bounds. Those flying drones using some kind of object is out of bounds. And now we have AI in progress. AI is now there. There must be rules that safeguard AI-driven profiling. We also have the state privacy laws, which are expanding rapidly in various states in the United States. Very, very importantly, we have the AI governance legislation. AI have come. We had crypto coming in immediately. We now had various countries creating laws regarding the use of cryptocurrency. Why? When cryptocurrency came in, crypto, as we all know, is a decentralized currency, which means that any transaction that takes place in crypto cannot be traced, which now aids money laundering, which now aids crimes. Countries now had to suddenly set teams to understudy crypto and know what is crypto, know what is decentralized currency and Web 3.0, with the aim of creating laws and rules regarding all of that. AI has come. With the aid of AI, several data could be collected. There must be rules regarding the use of AI governance. In several universities now, there are now rules regarding the use of AI in research writing. Previously, when AI came in for research, a lot of universities simply came and said, we are banning the use of AI for research writing. Once you notice it, is plagiarism. But different groups and support groups came ahead to really study what is AI. AI simply means artificial intelligence. Now, rules are to be created regarding the good and the advantageous use of AI. because AI has now come to stay, is now very advantageous in research, aiding analysis, aiding data, and now various rules in federal universities are being crafted to even aid lecturers and researchers in the proper use of AI. But I will always tell my students, you must always use artificial intelligence smartly. You must know what you need before you go to artificial intelligence. Why? Let me give us a true scenario. I do give this scenario very much in my classes and some organizations. Now, let's take, for instance, I build a large language model. You know, AI simply means large language model. I build my own personal large language model, and it is targeted towards data privacy. Every one of us, I give you an assignment to simply go to the AI platform. I give you an assignment to talk about data. You dump the assignment there and the AI gives you the answer. What if I suddenly wake up to that experiment and I go to my back end and tell my back end, replace the word data, replace the word data with intelligence. What does that mean? I am telling the AI that anybody that comes in and type any work relating to data, replace it with intelligence. Because I need to know my students that are actually doing proper research or not. What's the resultant effect? You simply go in, key in the question I give to you in class, AI gives you the Microsoft Word assignment, you upload it on the platform without going through it. Even if you go through it, probably it is a 20-page assignment. It will be difficult for you to spot the difference because you are relying heavily on AI, on artificial intelligence. That is why we always say, if you must use artificial intelligence for research, you must come from a part of known to the part of unknown. You must know exactly what you are looking for, and you must know what AI actually needs to accomplish or aid you to accomplish. That is where we now come to AI governance, the use of AI governance as a rule and a legislation. Several countries and states that are going about that right now. Now, our case study will be looking at FTC and Facebook. FTC is the United States. In 2012, FTC and Facebook entered a consent requiring Facebook So, as we say, the Federal Trade Commission entered an agreement with Facebook requiring Facebook to get user consent before sharing data beyond their privacy setting and to implement a privacy program. Those of you that were not in the first class, Facebook actually violated that. What was the violation? Facebook allowed Cambridge Analytica and others to obtain user data without adequate consent, directly violating the 2012 consent order. The Federal Trade Commission found systemic failures in Facebook's privacy program. What was the penalty? 5 billion USD fine. $5 billion fine. Facebook was also required to restructure its privacy governance, new board privacy committee, quarterly certifications by the CEO, and also open up their platform for independent privacy assessors. Now, in Facebook as well as several organizations, we are now required to always appoint and recommend compliance officers. In my country over here now, it is a key requirement that every organization must have a privacy compliance officer. What is the role of the compliance officer? The compliance officer actually works along all departments, ensuring that privacy rules are being created, not just created, adhered to across the entire organizations. Facebook was also told to submit to external audits. What is the key lessons here? Consent orders are legally binding. A fine may come up, but the fine does not undo the millions that have been created to users. Before we have an in-house discussion, we are going to watch a video from privacy law experts. Let's see what they have for us. We're going to see a video from privacy law experts. Please, can you let me know if you can hear the audio?
No, we cannot.
Okay, okay.
Welcome to Behind the Headlines. I'm Lee Pacquiao. Last week, book retailer Barnes & Noble announced that PIN pad devices in 63 stores were hacked in an attempt to steal customers' payment card information. The company has since been sued by a customer over possible theft of her personal data. Joining me now to discuss is Lisa Soto, managing partner for Hunton & Williams' New York office and renowned expert on all things related to privacy law. Welcome. Thanks so much for coming in.
Thank you very much, Lee.
Is this just life in the modern world? These privacy issues and data breaches seem to be coming up quite a bit.
Welcome to Behind the Headlines. Last week, book retailer before that.
Okay, thank you. Thank you very much for watching that short presentation. And like you heard from the lady, most times clients and customers only come around after the breach have occurred. A lesson from there, my personal lesson, you must take proactive steps to prevent data breaches and not reactive. We must take proactive steps to prevent data breaches and not reactive. Because whatever we may do as reactive or as remedy cannot outdo the consequences of any data breach. It can only seek to serve punitive measures for what has happened, but it cannot roll back the damage that have occurred. Compliance is very, very important. Compliance is very, very important. Let's see some scenarios. We are talking about opting out of sharing of our data. It is legally permitted, ethically also permitted, majorly out of respect of autonomy. For data retention, it's legally permitted to keep data as long as it's commercially useful, but ethically expected to delete data when it is no longer necessary for the stated purpose. We discussed this last week. For children's data, the corpus threshold, that is the law regarding children, the threshold takes children as under 13 years. We must treat minors' data with heightened protection because it is assumed that minors don't really understand most times why they do what they do. So the floor is open for questions, contributions, and comments as it regards the law. Questions, contribution, and comments as it regards the law. Please let's do well to unmute our mic and participate, ask your questions, drop comments, share your various experiences in your various organizations or personal experiences. Thank you very much. The floor is open. Good evening, Lawrence. Thank you, sir. Wow, this is a very, very interesting topic for discussion. Please, can we discuss it? Can we discuss it? Can we hear some views of others? We have Queen here, we have Akintoye, Sophia, Idrissa, and Precious. Please, let's all unmute our mic and participate in this discussion. Let's hear our views. Okay, wow, this is interesting. This is interesting. Please, can someone else give another view? Can someone else give another view on this? Good evening. Okay, okay, okay. Do any other person have something to contribute to this? Okay. So, I'll make recourse to the law because this is a very good and interesting topic for debate. In fact, it's cases like this that usually lead countries to modify and amend various data privacy laws. That is only if the issues is taken up. Now, if we recourse to, in Nigeria, since this was a Nigerian case from the question that was asked, Nigeria actually has the Nigerian Data Protection Act of 2023. And before the Nigeria has the Nigerian Data Protection Regulation of 2019. And under those two frameworks, that framework, it actually states that this company that recycles a SIM card linked to an active, the keyword active, linked to an active criminal investigation has violated several obligations. Why? First of all, telecoms will say the companies are required to retain subscriber data for a defined period. So the company may say, yes, by my rules, I was meant to define to withhold this data for a particular period, let's say 6 months, 1 year, and that period has been exhausted. So by my own internal rules, I can now recycle this SIM card. Yes, you can do that, but by the country rules, if that is linked to an existing unresolved criminal case, you cannot do that. Like Akintoye also said, I've forgotten who said that. You should have asked questions. Due diligence must be followed before data repurposing. Due diligence must be followed. Why? Because that number was a very important piece of evidence. Now, harm has been caused to the lady in question by negligent data handling by the telecoms firm. At this point, you may not necessarily even blame the DSS because they had an active case going on. But I wouldn't know. Some of these things also depends on the country's framework. In 2 years ago in Nigeria, I did a pitch to the military and I was canvassing for a unified system of data security for sharing of military intelligence. As if I knew there was a case like this. What was I proposing? I proposed that on that system, the military organizations, the health organizations, telecoms organizations, educational organizations, they are sharing one knowledge such that if a crime is committed and a face is being looked out for, they drop it on that database and it goes round. So if this was done like it's done in other countries, they would know, the DSS, the military, the police would have flagged this number somewhere and not just within their own internal agencies. So if you're asking if this lady can sue, yes, she can sue on multiple grounds. On the grounds of negligence, remember we are talking about the law right now. So we are actually lawyers right now. She can sue on the grounds of negligence. She can sue if she go back to study the law or she gets good legal counsel to represent her. They can sue that the telecoms firm breached the NDPA and the NDPR Act because those acts also give individuals the right to seek redress for harm caused by improper data handling. She can also sue that her constitutional rights was violated, was violated, and she will sue it in a civil court. Now, even NCC in Nigeria is called the Nigerian Communications Commission. They also have their code of conduct practices, and they have the right to also sue that telecoms firm if the lady actually lodged a complaint there. But this is the reality. Several countries have the way the justice operates. Within the case, probably Nigeria, it may be challenging because there must be a link that will be tied directly between the telecoms action and an arrest. Strong documentation, legal representation is expensive, and there's a case for bias also, and the court process may move slowly. So if I was the lady, I would lodge a complaint to both NDPC and NCC. Now let's go back to our course. Still relating to this question, we go back to our course because the telecom firm will talk about data timeline. On a data timeline, the SIM was recycled before it was safe to do so. Yes, I have a rule regarding recycling of SIM cards, but is it safe? We have studied in this course now that any hardware that is not used, the data should be trashed and recycled and given to someone else. But there must always be exceptions. The rule was created, and also there were some, sometimes we call it extenuating circumstances that must always be looked out for. Fine. We are talking about compliance. Remember, we said compliance is the floor, but not the ceiling. How does it apply now? it is possible that the telecoms firm technically complied with the standard SIM recycling procedure, but ethical governance demanded that there should have been a check against criminal investigation databases. Now, how do we close with this? The law actually gives the lady a basis to seek redress. That is the law. But whether she wins or not depends on evidence, depends on documentation, depends on access to legal representation. But also, most importantly, there should be a governance framework that has to do with recycling of numbers. If we had some government representation here, these are questions and debates we should take up as as a communique arising from the study of this victory course, the law. The law is very important. Probably whatever we decide from here would lead to creation of several good rules and synergy between the telecoms firm and the law enforcement agents. Because I'll tell you this case we are hearing is just one of several cases that keep reoccurring. I have seen instances, people get lines, others call them, oh, this is the line I was using, it didn't belong to me, I want to speak with someone else. There must be a legal concept. And the legal concept behind this, sometimes there's a name we call it negligent policy design. Negligent policy design. A policy was designed, but it was negligent because it didn't take into account several things. Regulation matters. Governance matters. When a company says we followed our rules and the rules leads to an issue, that means the rules were wrong. That means the rules must hold the company accountable. That is the difference between having a governance document and having genuine governance. And thank you very much for this question, because this is one of the best real world cases that we are going to encounter. And what I'm going to do, I'm going to put it as a discussional forum. Let's give our various views so that other of our colleagues will get these views. I'll write down the question later on, I'll paraphrase it and put it on the forum. So you could think through it, read through your various country laws. You could liken the question to what applies in your country. This particular question, I mean, you check out the rules in your country that has to do with this, and you would also apply that discussional question regarding that. So, do we have any other question, please? Do we have questions? Any other question or contribution before we end the class for today? Any other person to give any question or contribution? Okay. Yeah, that's right. I just wish that we have access to the lady in the course of this our 8 week program. Probably if we have access to her, we will try to support her and use the lessons we are learning from this program. Probably get a lawyer and see how we can make all these findings and move it to to a logical conclusion. So any other comments, contribution? Thank you very much, Akinto. Any other comments, contributions so we could end for today? Okay, so in the absence of none, I just want to thank us for partaking in this class. And please, I plead with us, let's read the document I sent. You could watch the video again. If you need to connect with me, you could do that. I've dropped my phone number on the chat box. You could do it via WhatsApp. You could do it via mail. You all have my email addresses, or you could send a private chat on the Google Classroom platform, and I will always reply to that. With that, I say have a lovely day and wish you the rest of the week. See you again, same time, Tuesday next week. Thank you. Bye-bye. So Sophia, thanks for coming. Queen, thanks for coming. Treasures, Lawrence, Akintoye, everyone that came, thanks for joining the class.